public figures. In a way, but this is coming up. The MPs, the ministers have to declare, the judges have to declare, the area of privacy is becoming minimized. Request others to participate and give their views. Yes.
Ultimate information collected from the legitimate exercise of taping and tapping the telephone and conversations can be put to the public.
You're talking about radio tapes.
We have a law in our country that for legitimate means we can tap the telephones for public security reasons, for tax.
It's an invasion of privacy.
Exactly. The tax evasion or friendly relation, security reasons. But when the agency is going for tapping the conversations, they come into possession a lot of other information also, which may affect others. We have a case, a very interesting question pending in Supreme Court, whether that part of the information which does not relate to the tax evasion, the legitimate purpose for which the phone was tapped, can be used. Incidentally, one of the persons who was conversing is a leading industrialist. He may not have nothing much to hide, but even his personal preferences, his places where he visits, what does he do, it is personal domain. It's the right of privacy. As Lord Walker said, the right of privacy, there's a lot of tension and that must be protected. We remember a few years ago in UP, state of UP, tapes of one important politician, Mr. Amar Singh, were leaked out. And the tapping was also illegal. But another thing which we have to see is whether the information collected, if it is damaging to public interest, all right. But sometimes the information which comes out also shows how the government functions. In that particular tapes, we found that one of the most controversial job of the government to fix the sugarcane price for sugar industry, which used to have a lot of litigation and a lot of guidelines, were fixed by a very interesting conversation where the Chief Minister could not even hear what the other side is saying and said, do you think that a price of that much will be sufficient? Chief Minister said, I don't know, I can't hear you properly, but then whatever you say is right. We have a lot of interesting issues also coming up, but this is certainly an issue which has to be addressed to how much part of the conversation which is legitimately correct can be put to use or can be leaked out. The another area is that WikiLeaks, which is now engaging the attention of the entire world, and consulates were intercepted are being made public. Thank you.
The other day,
may I request Justice Katria, if it does not affect with your privacy, can you tell us how are you? Okay?
I am very fine, sir.
Thank you.
No, the privacy is not included. I am indeed very grateful to you for the concern shown for me. The other day I delivered a judgment in division bench sitting in a field under Right to Information Act. The person had filed an application before the Public Service Commission there, asking for quite a number of informations, and one of them, which was the subject matter of controversy, that he wanted to know the names of the interviewers and also wanted photocopy of the signatures of the interviewers on the entire statement of mark sheet. That was denied to him. He went to the Information Commission. Information Commission held two things. He said that he is a mere busybody because he was himself not an applicant for the interview there. And secondly, he said that the privacy of the interviewers cannot be disclosed. He came to the High Court, the matter was taken up by a learned single judge who dismissed the writ petition and upheld the order of the Information Commission. Came up in appeal before me. I disagreed with the Information Commission as well as the learned single judge, and I held two things. That in the scheme of the Right to Information Act in India, the concept of locus standi has been completely abolished. Therefore, he is not a mere busybody. Anybody who is not interested with the subject matter can ask for the information. And his personal interest or question of locus standi can never be in dispute now. Secondly, I said that the interviewers were visible to everybody, all the candidates. Their egress ingress was public, everybody had seen them. Now, judges also deliver their judgments in open court, hear the matters, and everybody knows the names of the judges. Their names are printed on the cause list of the day, and names are to be found in the judgments also. Therefore, the names of the interviewers have also to be disclosed. So the question of photocopy of the signature is concerned, I denied that. I said that will serve no public purpose. He has perhaps done it out of sheer inexperience or out of, it does not serve any public purpose. So it may have the potential danger of copying his signature. This is the position. Therefore, as Mr. Justice Ganguly rightly said, this is a new and burgeoning branch of law and has to be taken very seriously. Thank you very much.
Could I ask a question? Do you have in India data protection principles which are in your law and regulate, as we have in Europe, what you do about, for example, telephone tapping, monitoring, hacking, and so on, and the misuse of private information? Because we have various conventions, treaties, which are containing rather strict data protection principles. And I'm never clear, of course, as to what extent India is party to any of the international treaties on any of these matters. I was going to ask the same question before on child labour, but on this issue, is there detailed legislation protecting against the misuse of data, personal data, or is it something the judges will have to develop in their lawmaking function?
I can try to answer this. This telephone tapping in India is regulated by an old act, Section 3 of the Telegraph Act, and presently there are lots of, if I must say, executive instructions which are coming to regulate this field. Suppose if the government has to take a decision whether the telephone of X or Y has to stand, and if that decision is taken, that's a structured decision. So that decision is open to judicial review. Suppose my telephone is being tapped and I come to know it's being tapped, then I have a right to question the reasonableness of that decision. But the law has yet to develop, and as Justice Ambani has said, there are a couple of very challenging cases which have come up. Unfortunately, I am on the bench. My freedom of speech is a little constrained on this subject. And others can speak on this, but so as I am concerned, it's very difficult for me to speak on this.
I was thinking of not just government tapping, but say a newspaper.
No, only the government can tap, and no newspaper agency, no private agency. It is still controlled by the government, this telephone business. Therefore, I don't think in our country it is permissible for a newspaper legally to tap anything. No.
Permission check. The right of privacy has two facets. One,
concerning the public life, public aspects, another concerning the private aspects. Again, as far as public personalities are concerned, they are under the public gain. Whatever information collected and given to the public, if it is in the public interest, perhaps they are protected, it does not amount to offence nor liable under tort. As far as private life is concerned, in India, a tendency is growing among the media to indulge in sting operations. That is, they secretly follow and then collect information, sometimes videograph them or tape them, and they are given to public. In such cases, I think the right of privacy does not appear to be a new invention of a principle. This principle is inherent in the law of defamation, in the law of torts. We have already this principle. See, even in the case where you make some libel or a slander, you become liable if it is not in a public interest. The same principle applies even in the case of a tort. You give out an information of a private life of a person which is not of a public importance or public interest, then the person who violates the privacy becomes liable under the law of tort in the Indian context. And I think in this situation, and I want to know, it's very interesting that Lord Leicester said that the defamation law, libel law, everything is abolished. What exactly is the position now with regard to the criminal liability? Of course, if it is a libelation of a criminal liability, it's a different matter. What about the liability under the tort for damages?
Just come to my notice, and I am bringing it to the knowledge of this august house. Under the Constitution of the Republic of South Africa, there is some very interesting question. You see, if you look at, I think we call it article or section? Section 14, which codifies the right of privacy. I am just reading out. It's very interesting. Everyone has a right to privacy, which includes the right not to have, since it counts in negative form, not to have their person or home searched, B, their property searched, C, their possessions seized, and D, the privacy of their communication infringed. Very broad-based right. Now if you look at another section of this Constitution, section 32, everyone has a right of access to A, any information held by the state, and B, very wide, any information that is held by another person and that is required for the exercise or protection of any rights, very wide. How to balance between 14 and 32? And there is a limitation clause also. There is 36, limitation of rights, section 36. The rights in this Bill of Rights will be limited only in terms of the general application to the extent that the limitation is reasonable and justifiable in an open and democratic society based on human dignity, equality and freedom, taking into account all relevant factors including A, the nature of the right, B, the importance of the purpose of the limitation, C, the nature and extent of the limitation, D, the relation between the limitation and its purpose, and E, less restrictive means to achieve the purpose. Very interesting situation, I think, and very challenging. I think no other constituent, subject to my limited knowledge, throws this right of privacy, right of access, and the limitation on these rights in such clear and tangible terms. I request my learned judge to speak on this.
Well, put very briefly, I think the formulation of Article 13 or Section 13 is drawn very closely from the ICCPR, so they're quite widely recognized provisions for giving some sort of context to privacy. And in our jurisprudence, we've also, responding to what Lord Walker said about what is the content of privacy, we've established a core and penumbra notion, that the closer you come to the intimate life of people, so sexual conduct, home life, the more intense your privacy interests are, the more you move out into the public sphere, the more tenuous your privacy interests are. So, for example, your privacy in your workplace is less acute than your privacy in your bedroom. And when it's then weighing the justification analysis against the privacy concerns, the importance of the purpose of the limitation of privacy will be much more easier to sustain the closer you are to the penumbra of privacy. That's a model somewhat similar to the approach in Germany, I think. In relation to freedom of information, it is unusual to find it in the Bill of Rights, but again I remind you that our Bill of Rights is a 1996 Bill of Rights, and we've been able to draw on experience in many jurisdictions and many international conventions. But as there often is, there's a little footnote to that. And the footnote is that the schedule to the Constitution requires there to be legislation enacted to give effect to the access to information right. And in fact, Parliament was put on terms to enact legislation within a 5-year period, very similarly to the equality legislation which I discussed yesterday. And we call it PIA, the Promotion of Access to Information Act, came into force in the year 2000. And it has a very careful and thorough dealing with what sorts of information you're entitled to, the processes for getting the information, and that information is then disclosed. I have to say that, like I think governments everywhere, that there hasn't been the most wholehearted embracing of the principles of access to information. So we are seeing quite a bit of litigation around it. But by and large, most of the information at the moment is sought from the state, and one individual could not seek private information held about another individual unless they could show it's directly relevant to their rights. So the potential for breach of privacy is less. What is interesting, though, is it does also apply, as much of the South African Bill of Rights does, in horizontally. So corporations in particular are also under obligations to disclose information, but we similarly have the data protection requirements as well. So it's always a balancing between ensuring that you balance privacy on the one hand and people's entitlement to privacy on the other, on that hand, with an entitlement to information. And it's very context-driven, very much like the privacy litigation that we'll need to discuss.
Well, what happens to paternity cases? I'm sure there are similar cases come in South Africa. Dispute.
Well, paternity cases, they occur all the time, and where there are disputes of paternity, generally there will be genetic testing to determine paternity. And there are sometimes disputes about whether those tests are accurate or not.
But any paternity test has to be carried out in infringing, basically. But your person has to be scratched in that sense. You're saying nobody can scratch or touch your person, and that has to be done.
Yeah.
But the balance has to be struck, you're right.
A balance has to be struck, and generally we have very strong rights of the child, and where a mother can establish some reasonable connection or likelihood that the man is the father. Yes, she has to establish that kind of relationship, and she has to assert all of that. Once she's done that, if he denies it, she would be entitled to insist on a paternity test. But you can't do that without some very basic establishment that there has been an ongoing relationship.
Can I ask a question? May I ask a question? No.
The paternity test?
No, that's one of my I wonder whether you judges in India do the same as the South African Constitution suggests, which is you call on the legislature and give them a chance to put the problem right before you have to step in a more intrusive way. Or is that not a judicial technique you often use? Because certainly in, say, the British system, it would be normal for the courts, in partnership with the other branches, to say, well, this is a matter that should be dealt with by the legislature, and they would only intervene if they were clear that it was not the case, and be very careful of not usurping the other two branches. The South African Constitution, very wisely, actually tries to encourage this tendency, and Taylor Reagan's court has many times given these other institutions a chance to put the problem right. And I just wonder whether this is an Indian judicial technique that is used at all or often.
Well, the judicial technique is on a swing of the pendulum. Initially, when we started our journey on constitutional jurisprudence, that was the Gopalan days, when we all the time referred to the wisdom of the Parliament, hardly ever questioned it. But after emergency, the situation has just come on the other side. We have invoked the concept of due process in our laws expressly. So now it is more or less the judge's decision of what is just, fair and reasonable of the law which is enacted by Parliament. Though we are very frequently reminded, as is said by Lord Walker, that we are unelected representative and we are deciding what is good for the people and bad for the people.